the latest agenda? Because I only have the one that got mailed.
What do you need?
The latest agenda?
Got it.
Thank you. Oh, okay.
Okay, we all ready?
Ready?
Okay, we'll get started. I call the meeting to order. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Please remain standing for a minute. We're going to just recognize a moment of silence for the people who lost their lives on Halloween in New York City. Thank you. Okay, welcome to the November 2nd, 2017 Town of Riverhead Planning Board meeting. Just a point of information, if anyone is here for the Great Rock Clubhouse expansion public hearing, that is not taking place tonight. I don't want you to wait around for an hour to find out that it's not on the agenda. It's been adjourned, and the applicant asked us to read a letter that he wrote requesting the adjournment, so we'll read that. And you're welcome to stay for the whole meeting, but that will not be subject of a public hearing tonight. It'll be on for the first meeting in December.
Dear Chairman Carey, we have been advised by the Town of Riverhead Supervisor's Office that it has received declarations from residents that the Great Rock Golf Club has not provided proper notice of the public hearing on its site plan authorized by Resolution Number 2017-103 and scheduled for November 2nd, 2017 at 7 p.m. Although we disagree with the assertion that we have not correctly noticed the public hearing, as enclosed time and GPS stamped photographs of the public hearing, notice signs, the U.S. Postal Service certified mail receipts, and excerpt from Newsday's legal notice section indicate otherwise. In deference to the Town of Riverhead Supervisor's Office and for the avoidance of doubt, we respectfully request an adjournment of our public hearing authorized by Resolution 2017-103 for November 2nd, 2017 at 7 p.m. to the next available public hearing date of December 7th, 2017 at 7 p.m. Thank you for your consideration. Respectfully, Fairway Drive Holdings.
Okay, so first meeting in December is when that public hearing will come up. You're welcome to come back, but then again, you're welcome to stay for our regular meeting tonight. Okay, first item on our agenda is a discussion item for NERP tractor supply. Okay, good evening. Just state your names for the record, please.
Eric Nine, Bowler Engineering, 2929 Expressway Drive, Hauppauge, New York.
Mark Diodato, New England Retail Properties.
John Montecalvo, property owner.
Okay, so Greg, we had questions on the monitoring wells due to the inactivity reports from the DEC. So I think that's what our main focus of our conversation is for tonight.
I'll let Jeff Seaman, he had written a memo regarding the findings of information that was provided to us. We can continue from there.
Okay.
Thank you. The applicant did submit soil borings up in the shallower depths of the soil borings. There were some minor traces of debris representative of fill. I think the deepest of that sample that contained debris was 6 feet, although the borings themselves went much deeper than that. Historically, the New York State DEC had required the site to do some monitoring through 2011. And I am gathering that one of the concerns from the comments from the board and from internal discussions with staff is that unknown question as to what has happened since the monitoring had stopped. I must state that the way DEC does approach these monitoring programs, if they do not find parameters that they have specified be sampled for in the groundwater that exceed certain thresholds, then they did continue to monitor over a longer period of time. DEC then just suspends that testing, and they don't even take it up to the next level of analytical requirements. But the site is still active, and that's pretty much where we are right now. I would certainly suspect, and I think the applicant's aware that in the section under review for this particular application, the 7 acres in the front to the north is where the sampling program was done for the soil borings. They are going to have to dispose of some debris, I would imagine, if the application goes forward. My experience dictates that even though the soil borings come up with a few problems, once you get into the excavation, that can grow. But that's an issue that is often dealt with during construction. The main question here is that the entire site, prior to any subdivision, is about 50 acres. So this board is really looking at the existing parcel. Then you have to take a second look at what we're doing with regard to tractor supply for the northerly 7+ acres.
Okay, so when was the last time those monitoring wells were sampled?
2011. Jeff is
2011.
correct.
2011, okay.
What they did at that time is that they said that there was no need to test any further. I think they had tested them for 6 or 7 or 8 years.
Yes, yeah. I think it was
And it
7
was
years.
No problems, and they said that it was fine, didn't need any more testing.
When were the soil borings done?
Your report was done,
May 2017.
I mean, it was recently, right?
Okay, so the soil borings were done well after the last set of samples that were taken, were collected,
Correct.
right? And in
Where
the
the,
soil borings, they identified some,
I think the report was dated May 31st,
Correct.
2017.
okay, do we have a location of the monitoring wells?
I don't have a map for the monitoring wells, and one of the questions I think we had asked, are the wells still intact? Are they still,
I believe the wells are
There.
still there. I don't know if they're operable. I don't know how that functions, but that's under the DEC's jurisdiction, so. I don't-
typically once, depending upon the development of the well, once it's a monitoring well, that's usually only 2 to 4 inches in diameter, PVC, and once they're installed, they usually just cap them and leave them there, unless you're asked to close them.
Now, the debris, there was an existing house there on that site. Other than that, it's virgin land where Tractor Supply is gonna go. So maybe it might have been from an old foundation or whatever, I don't know.
We picked up plastic, brick, asphalt, concrete, brick, asphalt, some metal. In the upper 0 to 6 feet below ground surface.
So, you know, myself, I'd like to see some more, another set of samples before we go ahead and allow the property to be subdivided, for several reasons. If, and hopefully it's not the case, if some remediation activities have to take place, depending on the travel of the groundwater, whether it goes north or south or northeast, that northern portion could be very, very important to the remediation.
I
So-
believe it flows due west, Stan.
I'd have to challenge you on that. I think it flows northeast from that location. But,
No, you're correct. It flows east. It does flow east, yeah.
so,
I have that backwards.
You know, we're not asking you to go put in additional monitoring wells. I'd like to see the location of the existing monitoring wells, see if you could still, you know, collect samples. It's not a very expensive proposition to do that.
Stan, are you talking about the wells on the entire site?
Well, there's two of them we're talking about, right? That the DEC had.
There's also an existing well where Tractor Supply is gonna go, too.
What was
There's a well
that
there,
used
too.
for? Was that
I
a
think
domestic
that was
well?
for irrigation for the farm that was there at one
Yeah,
time.
it was like a potable water type well that they believe was originally installed when it was a farm.
Well-
Is that operational? if I can
Well,
correct?
It is. It's actually where their location is gonna be.
Well, that would be helpful if we knew the depth of that too, but,
How would
Um,
we find that, Jeff? That-
You might have a well record, or, I mean, you could certainly
Some kind
get
of
a depth
sonar or
on,
something?
a well driller
Yeah.
might be able to put down like a
Some
probe.
kind of probe or
Yeah.
something.
But, you know, I think it's a good project, and I like it. I think it would be great for the area. I'm not opposed to it. I don't want you to get me wrong, and the rest of the board could speak up, but, you know, given the report of the soil borings, I would just like to see more recent sampling. Because if something does come up and we subdivide it, then it becomes an issue.
Are you talking about the entire site?
No, they have two existing monitoring wells, and,
On the 50-acre piece?
yeah,
I disagree. I
Okay.
think we should, if there's a well on the Tractor Supply piece, and you can check that, I'd be okay with that, but if the DEC's monitoring the site, and we're gonna do a subdivision,
they haven't since
No,
2011.
no, they have. There's a daily monitor there. They're not monitoring water,
kind
but
of-
they're monitoring soils and the whole
Right,
operation.
and the soil boring that we have had questionable material in it. So if the well that is used for potable use is 100 feet, and we're only seeing the questionable material at 6 feet, you're not gonna see it in a deeper well.
I just want to chime in here, sorry. I believe the debris material being referenced is not of environmental concern, it's of structural concern. So it's more relative to the installation of the foundations of the buildings, that it would have to be over-excavated so that you're not sitting on it. I didn't see any evidence in the investigations provided that indicated there was an environmental concern with that material. So it's kind of two separate things. There's the geotechnical side as far as the structural stability of the soil, and then there's the environmental side, so.
But it's been a very long time since samples were collected, so.
Well, we didn't get groundwater, because we went to 32 feet, groundwater is deeper than 32 feet.
Well, didn't you just state that there's still, Mr. Montegallo, that they're still monitoring that site?
Yes, on a daily basis.
On a daily basis?
Yes.
So is there any reporting being done?
I submitted 900 pages of reports.
And
There's a
are
report
they up to
written-
date?
Yes.
Are they recent?
What type
Yes.
of monitoring?
It's DEC regulations, you know, they're, as far as soils and whatever else.
I think we're getting confused between the groundwater testing and then what's being tested by DEC, what's happening above the ground in terms of,
Right.
so I think we're comparing apples and oranges. We just want to make sure we're talking about the same thing when we talk about testing. John, I think the last groundwater testing, correct me if I'm wrong, was done in 2011?
Correct.
Okay, but of what's happening above ground is being tested to this day.
On a daily basis. Yes,
Monitored.
yes,
That to be clear with everybody.
yes. They do analyticals, whatever, you know, whatever they do with the DEC, I don't really
Jeff, you said you have done soil borings. Did you do an analysis of the
No,
material? to see
the
what was
applicant
in it?
did these for, you know, bearing capacity, structural
Oh.
integrity, but reading the boring reports, I could see the debris. But we have not seen the other DEC reports that you were referring to, and perhaps that would be of great assistance to the board to take a look at that. And the other option would be to perhaps even grab some of the soil samples for analyses above and beyond just the inspection for the structural integrity, if that's still a concern. Because if you picked up some contaminants in the soils, even if you didn't have a groundwater monitoring well, that would give you some indication as to the environmental quality.
Are you
Because
talking
I
about
think
just on this 7-acre site, or are you talking about the entire site?
Well, therein lies the rub, because the 7 acres aren't subdivided yet, so.
No, they're trying
you-
to subdivide,
Right.
and I guess the applicant wants to buy the 7-acre parcel. Wouldn't it be prudent to worry about the other acres when they come for whatever plan they're gonna, I don't know why we would subject the 7 acres to whatever's going on the bigger
Because
parcel.
the flow with the groundwater, if the back parcel is contaminated and the groundwater flows towards the front, you may need that for remediation activities. And once it's gone, you're not gonna be able to use it for remediation activities. And the applicants in front of us now, we know what kind of activity is on the back parcel. I mean, to go and sample 2 existing monitoring wells for a few $100s each would get this thing on its way if they're clean. I don't understand what the big problem is. I mean, less than $1,000 and you guys could be off and running, and everybody's comfortable with what's going on there.
How do we find out where the water does flow? I think it does flow east, due east,
Northeast.
northeast.
You're somewhat on the divide line, and I agree with Stan that the water is moving north and northeast toward the 7 acres.
And since one of those wells is on that 7.5 acre piece, I mean, that would clear it up. I mean, that would seem to me,
Yes.
that would be an inexpensive way to do it, I agree.
From what I recall, the wells are in the very north section of the property. But there is a well, like I said, up front where they're gonna build, would be immediately where they're gonna build that. But I don't know the depth of it or any of that.
I'm sure if DEC had monitored it, they had set a well cluster down gradient and another well cluster up gradient so that they would capture the water as it was moving to the northeast.
They might have, Jeff, but it's nowhere near their property, I know that.
Okay. Maybe we
Closest
can,
one would be that existing well.
that
up
existing
there.
well.
Yeah,
That was used for potable water,
yes,
the one on our piece.
yes.
I'd be concerned.
But I don't know
I'd be
how deep it
concerned
is.
about the property itself.
Well, do you know where the existing monitoring wells are?
Yes, they're in the northwest corner, I believe. Whereas his well.
They wouldn't be
is-
next to one another, they're probably on opposite sides, but.
No, excuse me, they're in the southwest corner, they're more towards the EPCAL property.
Okay. They wouldn't be right next to one another, they'd probably be on opposite ends of the property, because it would defeat the purpose. So,
I could check that though.
yeah, I mean, get us some sample results, I mean, that's my opinion, unless the board has any, wants to go in another direction, that's fine too, but I just,
But they are bringing in public water.
We
'cause-
talk, yeah, but if the groundwater's contaminated there, you may be required to clean it up. We don't know that. And that's, right now's the time to get a handle on it. And we said this 2 months ago when you were here, and we haven't gotten a map, we haven't gotten anything additional. Your reps were here, and I'm saying the same thing I said 2 months ago.
I agree with the chairman.
And again, don't get me wrong, I think it's a great project, and we're ready to move forward with it. It's just, we asked 2 months ago for monitoring well information, we haven't gotten it.
Mr. Chairman, may I make a suggestion also? If the DEC reports on the daily monitoring aren't available, there still is a stockpile of substantial size to the rear of the property. And maybe a composite sample from that would also be beneficial, since that site is still active and would remain active, and that would give you some indication on the quality of the material that's stockpiled there now.
I thought we submitted all that, but I will,
And
I'll
then,
check
then
that.
potentially going forward, that could be addressed later, but at least memorialized as this project moves forward. So the future boards that would have to revisit it would have some baseline information to look at in the future.
So we can't subdivide this and get these people going, because they're getting a little impatient.
Again, you were here 2 months ago, not you personally, but your reps or whoever's buying the property, we went over this. You could have somebody there in a week to sample those wells, and probably 2 weeks after that have sample results. For under $1,000.
guess whatever else you have from documentation from the DEC, include that too, so we can,
Yeah, I thought that was some, it was
Yeah, no,
900 pages.
No, all the analytical results for the water, and the groundwater monitoring, yes, we reviewed that. But if you have additional information, that would be
Yeah, it
helpful.
was the actual monitoring reports that I thought were submitted, it was like
Yeah.
900 pages.
Yes, but that was for the groundwater.
No, it was for the daily monitoring of the soil that comes in and out.
That we didn't see. We just checked with Greg too, so
I just saw the monitoring well stuff.
that would be a big help too.
Yeah, it's like that big.
Okay.
I paid the guy, it was a ridiculous amount of money to copy it.
Fine.
But I know we, if it didn't get to you, Greg, we will definitely get it. It's available, that's for sure.
so just so we're on the same page, Chairman, you want the water test wells and the aggregate in the back to be tested?
Right, the 2 existing monitoring wells. We're not asking you to put any additional. Just, 7 years is a long time, 6 years is a long time not to have, information. Now you're asking us to subdivide the lot so you could, you build out the front piece. It'd be poor planning if we allowed all this and then found out 3 months from now that, the property's contaminated.
Would I have any, because I know it's under the DEC's jurisdiction, can I still access those wells? I don't know the answer to that.
Sure, I don't see.
I know we could access the one that's on their property, because we use that. That's being used every day.
No.
It's not a monitoring well.
So, John, the monitoring wells are either gonna be capped, like we said, or if the spill was closed, they may ask you to abandon them in place, and that means they would have been backfilled with like bentonite or something like that. So in that case, they won't be sampleable, but right now, we have to find out where they are.
Okay.
And
If they are in the southeast corner, will that help us, Stan?
We had asked the location of them. I mean,
Well, 90% sure that's where they are. Would it be?
one of them may be.
Would it be better to use the one that's gonna be where they are? It's not a sampling well, but it's a well.
Let's take a look at where they are.
Okay. So I'll label where the well is on their property and where the other 2 wells are. Okay.
And if they're not accessible, if they've been partially capped, there's other options too. They're not very expensive. You could do a hydro punch through it and just sample the soil down there.
Mr. Chairman, is there a particular analytes? Are we looking for standard Suffolk County protocol?
We could,
If you want to run through the same parameters that were used
Prior?
prior for DEC, VOCs, semis, metals,
Yep. Yeah, it's the Suffolk County, yeah.
pesticide hits, whatever.
Yeah, I'm sure whatever they do is pretty extensive.
Exactly, yes. And then that would standardize the same baseline information that we started with.
Jeff,
Thank you.
Jeff, just to be clear, this is on the soil, not water.
This is on the
the water.
water.
Water. So they're gonna go down 30-some-odd feet, you said, to water?
Well, they
Yeah,
have
the
existing
the
monitoring
borings
wells.
we did are deeper than 38 feet. We're hoping to find the wells that were previously sampled and the spill was closed back in 2011, resample those wells to get a current baseline of what's there, if I'm understanding correctly.
Yes, and with a certified New York State
Laboratory.
Health Department lab, so that a chain of custody, the whole thing, so it's nice and clear.
Absolutely.
And if there are no wells, or if they have been capped, what would you like us to do? Or like John to do? New wells?
I didn't hear you, I'm sorry.
What would you like the property owner to do if those wells are being capped? If they're not, they're drill new wells, I just wanna make sure we're clear so we don't come back here next time without.
You could look into a hydro punch, or we could look at the potable well and maybe do some soil samples.
Okay, that's what we'll do.
Is there any other
Are
issues?
there- I think this is the biggest issue.
And once
Are
we
there
have
any
that,
other-
we'll move this along for you.
Okay.
Okay.
All right, thank you, Jane.
Thank you.
Thank you, gentlemen.
Thank you.
Greg.
Thank you.
Okay, next item on our agenda is a public hearing for a minor subdivision of Rock Camp.
Pete Danaski for the Rotkamp family who sit in the second row. I'd also noticed there are two ladies here today and not one. And I understand we're losing our most valuable player in the front of you, Emily, who's advancing to the accounting department hoping to be a CPA. So I know she's going to be missed. I know she's going to bigger and better places, but you know, maybe not necessarily better, but bigger eventually. And I know she's got a very capable replacement here today. So I just wanted to note her, we're going to miss her pleasant smile. That having been said, I handed up the affidavits of posting, and I explained in a letter to the board, but I'll repeat it for the members of the public, that this application is necessitated by a brief history of events. In 1999, my clients bought from Mrs. Kobolensky 2 parcels of land, one of which was stripped of development rights by a deed of development rights on what I describe as the farm parcel. Separate and apart from the farm parcel was a second parcel in which the development rights were not stripped. That area was 1 acre in size. 1 acre was the zoning at the time in the town's then zoning code. The clients got 2 tax bills and have owned this property for a good deal of time. Ultimately, they did some estate planning and transferred the farm parcel to the parents as tenants in common, and then left Jason, the son, with the buildable area, the second parcel, which is 1 acre in size. Like all farming families, there's an attempt to do a little estate planning and an attempt to give away or transfer properties to various children. If you have 1 child, it may only be 1 child that's getting the assets. If you have more than 1, you have to spread your wealth. And also when you want to give away or transfer a parcel, you don't want to necessarily, while you're still young and vibrant, give away the farm. So this application is necessitated by Jason going to the health department with a building permit application and saying, here's the plan for my house on my 1 acre lot. And the health department says, we don't recognize the lot. So it shocked the family that this wasn't a lot. And this many times happens in the town where the deed of development rights creates a separate tax bill, creates a separate parcel. Deeds are transferred per parcels and Suffolk County tax map numbers, but no one came to the Riverhead Town Planning Board to subdivide the lot from the smaller area from the larger area. And that's what this application is about. We're only seeking to do 1 residence on the buildable area that's not subject to the deed of development rights. The second area will be created as a second lot on which a house cannot be built. I post the sign, and we have to give necessary notices. We file an ag data statement so folks get it. And I think, you know, everybody's going to say, well, there must be some big project there. It's 1 house for our son, and it's on 1 acre of land. That briefly said is the application.
Okay.
Have you been to the health department?
We have to wait for the seeker determination to be made by this board.
Yeah, by us.
So I'm waiting for that result and the approval of the subdivision.
So they received 2 tax bills
Correct.
all these years,
Yes.
18 years.
and the county didn't recognize.
That's correct. And if you go back to John Klein's days, some of you may remember who he was when he was responsible. I think there was an opinion that he rendered early on when this program first started that said he thought the intent at the time was to create lots, but that's never been the pattern that developed after that. And clearly I understand that, and it's unfortunate. So we don't want to give Jason, even though he's a great guy, we don't want to give him the farm yet, but we want him to build a house on a separate lot.
Okay. Is there public water by any chance?
No, there's not.
Any other questions from the board?
Any other buildings on the lot 2?
There's nothing
Outbuildings
on the
with a
lot
barn.
except for the small lot to be created has a barn on it. That's it.
Okay, anyone from the public want to comment on this application? Anyone from the public?
Move we close the public hearing.
Second the motion?
Okay, motion made and seconded to close the public hearing for the Rot Camp Minor subdivision. All in favor?
Aye.
Aye. Opposed? Okay, the public hearing is closed. Thank you.
Thank you very much. Have a good night.
Okay, next item on the agenda is a public hearing for the expansion of AutoZone on Route 58 in Riverhead.
Good evening.
Hi.
Heather Davis with Bergman Associates from Horseheads, New York. Hopefully Greg handed you all the updated site plans. We've made all of the changes that we talked about last time, additional landscaping. Parking spots are now 10 by 20. They will be resealing and restriping the entire parking lot to accommodate those new spaces and size. Also, there should be a photometric plan attached with that showing the reduced height of the light poles and light fixtures. There are a couple things we're still working on with the county in regards to Old Country Road. First one being there's 3 handicap ramps that need to be redesigned. We're getting survey this week. Redesign will happen next week. Still in contention about the island in the entrance exit. We're working with the county on that, hoping to get some resolution next week. We keep having a back and forth with them. But everything else has been updated and is in front of you.
Did they add irrigation to the front landscaping?
That is one item I didn't look at.
Okay, that was kind of a big point last time.
Okay,
We're gonna need to know that, because even you're gonna put new landscaping without water, you know what's gonna happen.
right, I think that they were going to put some in, that's a little, if there's already existing irrigation in there, I can check with them. It hasn't been something that AutoZone has really hit hard with. But I can make sure that it gets in there.
Please.
Okay, just 2 questions. We got the affidavits of posting? We didn't get them? Do you have the affidavits that it was posted for the public hearing?
I do not.
Okay. Can you attest that it was properly posted in accordance with the code?
Yes.
Okay, and do you have that information that you can turn into our secretary?
I don't have it with me.
But you have it?
Yes, I can
Okay.
forward it on.
And if you could just briefly explain for the record what the scope of this project is?
Sure. We are expanding the current AutoZone, an additional 1,500 square feet plus or minus, all within the proper setbacks set forth by your code. It's going to be additional storage for auto parts for sale. There will be no increase in traffic as far as deliveries or anything like that. And then we're just going to put more concrete instead of asphalt on the lot. And we also will be fixing and updating the garbage enclosure since it's fallen in disrepair.
Okay. Okay, any questions from the board? Pretty straightforward, right?
Well, it's just that it's the oddest shaped lot I've ever seen.
It's difficult.
Anyone from the public have any comments on this application? Please come up.
Good evening, Richard Israel. We are the neighbor of this parcel to the east. We have no objection to it. We think it's a great project. The only thing that we saw in reviewing the plans is They do have a temporary construction fence that will block our right-of-way. It's an active right-of-way that goes to the rear of our building and to a parcel to the north. So we would just like to work with them to make sure that that access is accessible. That's all. Thank you.
Thank you. Heather, maybe you could exchange information with Mr. Israel?
Sure, I'll get it right now.
Anyone else from the public want to comment on this application?
Mr. Chairman, I just want to make a point that, I don't know if we should close this at this point until staff verifies that the mailings went out and that it was properly posted, because I don't know if we should close it without actually knowing that.
Okay. How long, we have to specify how long we're going to leave it open? Till our next meeting, maybe, 2 weeks?
Fine.
2 weeks?
We have to, so that we're assured that, everything was done properly as
Okay,
far as
no
the
problem.
postings.
Stan, I apologize, I just got the phone with Bob Kozakevich. He said we can go ahead and have the hearing tonight, as long as she certifies, that, testifies that she did do the,
Which she did.
right, and she will provide that information to us. In the event that it's not provided or it's improper, then we'll have to repost the notice.
Okay, I'm satisfied with that.
Then we'll close it.
So we're gonna keep it open until the next meeting on December
No,
7th?
I'll move and close it.
All right.
Second. I'll move and close it.
Okay, motion made and seconded to close the public hearing for the auto zone expansion. All in favor?
Aye.
Opposed? Public hearing is closed.
Thank
Just turn
you.
that in as soon as you can. Thank you.
Okay.
Okay, item 3 on the agenda is to be adjourned to December 7th.
Three or four?
Number 3, Great Rock Clubhouse expansion.
I got the other, okay.
Jefferson, do we need to do a resolution to do that, or it's just adjourned until the 7th? That's it? Okay. Item 4, public hearing for,
Yeah, we received a certified letter inviting us to the hearing tonight.
well, you walked in, when I started the meeting, I don't know if you were here right at 7 o'clock?
No, we're 10 minutes late.
I had, right when we started, there was several other residents here, and we, at the request of the applicant, it was adjourned until December 7th, and we read a statement from the applicant as to why. So, sorry you didn't make it and you had to sit through it, but it's going to take place on December 7th.
At 7 PM. We'll be back.
Yeah, it's not gonna be reposted, so, just so you know, that's the date.
We'll be here.
Okay.
Tomorrow or the day.
Okay.
Motion to adjourn there.
Okay, next public hearing is for Riverhead Commons, Route 58 in Riverhead.
We can make a motion to adjourn.
You said we didn't.
You don't need a motion to adjourn?
No, he asked me if we needed a resolution.
You don't need a res though.
Okay, so somebody want to move to adjourn?
Yeah.
Sure. For Great Rock? Make a motion that the public hearing for Great Rock Clubhouse expansion be adjourned, so moved.
Second?
Okay, motion made and seconded to adjourn the public hearing to December 7th for Great Rock. All in favor?
Aye.
Opposed? Thank you, Emily. Okay, now number 4, Riverhead Commons.
Thank you.
Good evening. Isaac Israel on behalf of Riverhead Commons. This is for our site plan for our medical professional complex. The property is 6.14 acres, zone shopping center. That's permitted use. We're planning a campus-style medical office complex consisting of 4 buildings. The largest is 20,700 square feet, 9,000 square feet, 7,800 square feet, and 2,500 square feet. And been working on this, getting it through the planning process for quite a while.
Okay, so the most recent change was,
Address 780 Old Country Road, Riverhead.
the hookup to the Riverhead Sewer District, right? Because originally that wasn't
Yes.
proposed.
Yes, that is correct. We also have public water and natural gas.
Any questions from the board? Questions? We've been working on this for a
Yeah,
while.
Did we square away the cross connections?
Yes. The backflow device,
Yes, they're going to be located within one of the within the buildings.
right. Okay, anyone from the public have any comments on this application?
Okay, make a motion to close the public hearing for Riverhead Commons, so moved.
Second.
Okay, motion made and seconded to close the public hearing for Riverhead Commons. All in favor?
Aye.
Opposed? Public hearing's closed. Thank you. Okay, before we take up the resolutions, is there anyone from the public that wants to address the board on any of the resolutions? Good evening.
My name's Phil Barbado. I'm from the Riverhead Neighborhood Preservation Coalition, and I live in Jamesport. I'm hoping that resolution number 110, I'm hoping that the board can clarify this for me, because it's been so confusing. I really don't understand it. The original ZBA approval that allowed the pre-existing non-conforming use to continue specifically excluded retail as a future use. The planning board approval for the most recent, or the previous planning board approval said no restaurant or catering, no special events, and no outside music. Now it looks like we're dipping into those areas, the retail area. The other thing that's confusing to me is the parcel a pre-existing warehouse with the uses that come with a warehouse, or is it a parcel that is in the agricultural protection zone with the uses that go with that? And how could it be both? You're either a warehouse that was pre-existing with the uses that are allowed under warehouse, or you're in the APZ zone, which is what the property is currently zoned at. And it seems as though we keep crossing those lines between those uses in those two categories. So I was hoping someone could explain to me exactly what is the standing of this parcel, what is the zoning that applies, and how can you get retail out of it on either of those possibilities?
Well, Jefferson, can you answer those questions? I mean, we are well past that point in this process. They already have approvals, and when we went through the public hearing, all those questions were answered, but
Well, I
it
think
was- it
this
was
most
a-
recent,
Excuse me?
I'm sorry, isn't the most recent application, though, to expand for a restaurant use?
Right, but the public hearing was held last month.
Mhm.
So, I mean, there was an accessory use, if I'm not mistaken, that was granted by the zoning.
Which zoning?
The
Accessory
zoning board.
to warehouse or accessory to APZ?
Accessory to warehouse and processing for the use permit.
So the things that are going to be sold in the restaurant are things that were stored in the warehouse?
Again, I don't want to get into a debate about the use. Has not been determined not to be a restaurant, and we're here tonight to listen to comments about the resolution before you.
So you're saying we're down the road, whatever mistakes we made, and we can't correct them?
Well, this board didn't allow the accessory use. I mean, we've made determinations on whether or not it's classified as a restaurant.
It's not a restaurant, is that what
No.
you're saying?
No, it's not a full-service restaurant.
What is a full-service restaurant? You go and order your food, you sit down and you eat it? Or do you sit at a table and your wait staff comes and takes an order? What's the difference?
Well, I can have the staff advise you on that. We're talking about the resolution tonight.
Okay, well, all I'm saying is, this thing has morphed many, many times, and I just would hope you'd take that into consideration before you let it morph even further.
They are open for business already.
If the boat leaves the dock and it's sinking, that doesn't mean you don't bring it back to the dock,
Well, I
okay?
think it's sinking.
You know, the fact of the matter, that you think it's sinking is a matter of opinion.
Yeah.
Okay.
That's all.
You can come up if you'd like.
I was just gonna tell him I'd be happy to answer any questions.
Okay. Anyone else on the resolutions? Okay, resolution. Yeah, we're on the resolutions if you have a comment.
Yes, thank you.
Brian Lewis of Lewis Joes for the applicant on Resolution 2017-110. Just a couple of tweaks and one or two items I want to raise with the board. With regard to, I'm on page 3, and specifically the conditions listed there. The second condition references that there's to be no permanent or temporary enclosure of the outside patio without site plan approval. We have no problem with it insofar as a permanent structure goes that does warrant site plan approval. With regard to a temporary, however, we do take issue. We don't want to be in a situation where, for instance, we have art shows of local artists, and if it's inclement weather, we want them to be able to put up a temporary, one of those little gazebo deals or whatever it needs to be for a short period of time without having to go through the site plan approval process. And we think that's a fair reading, so we have no problem with the permanent aspect. We'd like the words "or temporary" deleted. And
Number 3. Did you say 2?
2. Page 3, number 2.
Thought the prior approval said no special events. Any art show or anything like that would require a special event from the town board.
Okay, but would you be willing to get a special permit?
Yeah, absolutely. What I'm saying is that I don't want a condition preventing a temporary enclosure without site plan approval. We would be happy to comply with the town code with regard to special event permits and the like for the erection of a temporary type of a structure like that. That's all we're asking, just not to be forced into the site plan approval process if we want to put up a temporary gazebo type of deal for 24 hours.
This is, I'm reading to you, this resolution, 2015-0092. This is condition number 2 of that approval. There shall be no special events such as weddings, festivals, or fairs held on the subject property.
But that's not what I'm getting at. What I'm getting at is, under the farm cidery law, which is what this is, we're supposed to encourage local everything, handcrafts, the sale of local products. That's all. I'm not talking about, maybe Mr. Murphy's misunderstanding of the scope of what I'm talking about. I'm talking about we're open for business, and on a random Saturday, we have some local artists have a display of their things outside, or a farmer's market type of idea where they have local produce and they want to that sort of thing is what I'm talking. I'm not talking about a special event. I'm just talking about an ordinary course of our business. We may have folks come over and do that. Another example, we have Peconic Bay, the hospital is going to be coming over. They want to do a fundraiser. If it looks like inclement weather and they want to put something up because they have people coming for the fundraiser that we've donated the facility for, and we want to be able to allow them to do that with a special event permit. I'm trying to think of other examples. A blood drive. We want to, on days that we're open, we may have blood drives come in. And if they want to set up on the patio, again, if they want to just shelter from the sun, whether it be an umbrella, I just don't want to get into this situation where we're making a site plan application amendment for something that's going to be up for a couple of hours.
Okay, and there wouldn't be any music because you're not allowed to have music.
No music, and that goes to my next one. So that's issue number 1. Issue 2, I would just, the prior language with regard to the outdoor music, I think was just clearer. It was, there will be no music played outside the building. I think that was clear. There's some tweaking that would, I I think should be done with number 3 as it's presently written, that there's just some redundant words, but that would be my suggestion on that piece. But yes, we have already agreed to take down the speakers, and there will be no music played outside whatsoever, live or otherwise.
Okay.
They were down 2 weeks.
No, they were down 2 weeks ago.
They were down right away. They were down right, and thank you, thank you. They were, we knew.
changed it, and he sent us a different one.
So with regard to item 4, that restricts, well, it says no changes to the size, configuration, or location of the kitchen, food preparation area. We have no problem with any of that without a site plan approval. With regard to the phrase including walk-in coolers or any other accessory uses of the building, we do take issue, as you may recall from the prior meetings, the walk-in coolers are not in this space, they're in a different space.
Right, but this is being approved as shown on your amended plan, so what this is saying is, and correct me if I'm not accurate, Jeff, they're okay where they are, the way you have it set up right now is what's being approved.
And I understand that, and we're fine with that, with all the kitchen and food prep equipment. What I was getting at is, the walk-in coolers themselves are not in this particular space, and they are movable within that that back space. So I don't know that we should need to get site plan approval to move what is effectively a large appliance. But that's one. But number 2 is, I'm not really clear on the phrase or any other accessory uses of the building. To me, an accessory use of the building is a use that is already permitted, so I don't know why we would need to get site plan approval if we were just using the building for an accessory use.
We just need to know, Mr. Chairman, where the walk-in coolers are going to be, because they are to be regulated under the building code. And when we go to do our inspection, we want to know where they are, so that we know that they're going to be properly vented or whatever the fire and building code is going to be.
Okay.
They can't be moving around, be a moving target for our inspectors who are out there trying to find them and knowing where they are.
So you're showing them on the revised site plan where they are.
Well, they don't now, but with the further condition down, Mr. Chairman, we want them to show it.
Okay.
Let's show it.
Yeah, that's what we were planning on showing it.
It's the accessory part that
It's the accessory part that I really take issue with, because I don't really understand what that means, and if it's an accessory use, I shouldn't have to bring our client back for site plan approval.
Okay.
That's, on that one, number 5, that states that there should be no change in the types or addition of food preparation and/or cooking equipment or appliances shall be permitted without site plan approval. A reading of that could mean that if one of our ovens breaks down and we put a new one in, we got to get site plan approval. A reading of that could be if we decide to replace it with Model X instead of Model Y, but it's the same type of thing, we need site plan approval. Another reading is, we're already approved for one soup kettle, but in the fall, if we want to have hot cider on a second soup kettle, we got to come to you for approval. So my suggestion would be just to tweak that by saying, instead of no change in the types, no material change in the types, so that we're not, and there's some reasonableness to when we need to come to you. We understand if we're making a wholesale change of equipment and structure, we have to come to you, but for, if we added a toaster, I'm trying to think of an example that doesn't really warrant a new site plan application. With regard to 8, this is just wordsmithing, I think it should be no permanent certificate of occupancy shall be issued. And last but not least, I'll just advise Mr. Murphy that we no longer have that office that is listed on the last page for my address. My address is 1 CA Plaza, Islandia, New York, Suite 225. But other than that, those are our comments.
Okay, thank you. Do you want to look at this if you don't have it?
No,
ready?
I just moved.
You
on
good?
it
Okay.
As you were going.
Okay, so first resolution is for TSA Capital.
Make a motion to move the TSA Capital Resolution number 108 of the Riverhead Planning Board. So moved.
Second.
Okay, motion made and seconded to approve Resolution 108 for TSA Capital, granting preliminary site plan approval. All in favor? Aye. Opposed? Resolution is approved. Number 2.
I'll move resolution number 109, which assumes lead agency declares a negative declaration for Eagle Auto Mall Warehouse and Office Edition, and also grants preliminary site plan approval.
Second the motion?
A motion made and seconded to approve Resolution 109, granting preliminary approval for Eagle Auto Mall Warehouse expansion. All in favor?
Aye.
Aye. Opposed? Resolution is approved.
I'll
Okay.
move resolution 110, Grapes and Greens, AKA Cider House.
Okay.
Discussion.
Let's talk about
Change the
amendments here or revisions. Number 2, the applicant asked just to, in number 2, to strike the word temporary. He talked about number 3 with the speakers. I'd like to leave that as is. Number 4, he asked us to strike everything after walk-in coolers. And on number 5, add the word material after no change. I'm okay with all of those with the exception of number 3. I'd like to leave that one as written.
Okay with that?
That's fine, and just,
Move it as amended.
just to be clear, with regard to, number 4, I'm okay with the language, shall be permitted without site plan approval. So, I recognize there are some instances where we do have to get site plan approval, so it's from walk-in coolers to building, that's what I'm asking.
Accessory uses,
Yeah,
right.
yeah,
We'll strike, or any accessory uses.
yes.
Second the motion as amended?
So, just for clarification on what are we doing with number 2?
I have it written down here, I'll give it to you, okay?
Um,
All in favor as amended?
Aye.
Opposed? Resolution's adopted as amended.
Go make cider.
Okay, any comments from the public on any matter in front of the planning board? Anyone from the public want to address the board? Okay, minutes of October 19th.
So moved? Second.
Okay, motion made and seconded to approve the minutes of October 19th. All in favor? Aye. Opposed? We do have a couple board discussion items tonight.
I just want to make a note, please, on the Dries application.
Dries?
D-R-I-E-S, Dries.
Oh, all right, Karen, but I can make a note.
Yeah, I've got a copy of a review, and I want to see the plan. I don't see the map. Is that, I think that's up near Tanger.
It's between Tanger 1 and Tanger 2.
Yeah.
Yeah, all right. It's something Karen's working on, but I'll get her the message.
Which one do you want to talk about first, Jeff? The
Solar,
light? Solar?
Solar code.
Okay.
At your next meeting, you have a discussion item to talk about the changes to the solar farm code. I gave you copies of the latest draft in your basket this evening. You have now, between now and next meeting, to review that.
Okay, just so the board is aware, this was something we did 2 years ago. We drafted some proposed solar code revisions when Councilman Gabrielson was still here. He kind of informally or unofficially signed off on them, and they haven't gone anywhere, so they've come back up now, and the town board is considering it, so we're probably going to get them back for comments at our next meeting, as Jefferson had mentioned.
The public hearing on the town board is going to be the first meeting in December. Second item, Ed, that's your
We have a memo here, we're just passing out. Emily, do you have this?
We've discussed this before. The most new lighting is LED because it's bright, it's energy efficient. It hasn't been passed on to code revision yet, and the board strongly feels that the town board should send it to code revision so we can update the code. Due mainly from Costco. One of the neighborhood communities there is complaining about the lights. I'm not sure if those are compliant. I don't think maybe Vinnie's been out there yet. But either way, we have to have the town address the LED light.
Riverhead modeled this law back. Southampton did a really exhaustive study that actually Hard Outside Consultant helped them draft it. Since then, LEDs have materialized and have changed the game, so to speak. A 25 watt incandescent bulb is not the same as a 25 watt LED. LEDs are twice
Yes, absolutely.
Jeff, you probably know Susan Harder.
That's who,
She's excellent resource for dark
that's
skies.
who we had in Southampton, so
Yeah.
maybe consider seeing if she can,
I'm sure she would.
the report's okay, we'll send that. out
Yes.
to- Okay, great.
Everybody's okay with that?
Yep.
And the last issue I have, just in terms of process, in terms of packets, our deadline to get resolutions to Emily, now Carissa, is 2 o'clock on Friday, so that we can get the packets out by the mail. The mail usually comes around 2:33, so that's our deadline, and we can do it. The problem is, some board members do not get their packets until Monday, so is this creating an issue with board members?
Well, as long as I get mine by Monday, I'm fine with it. I stop in during the week anyway, and I'm good with email too. If something comes in after or something, you can always email it to me. I check my emails every night.
Good with
No
everybody else?
problem.
Yeah, I'm good.
Monday is good. It's the later ones, like, when you pop one up on Wednesday or Thursday, that's what I have a problem.
Right.
Because
We try
I'm
to-
not necessarily near the emails.
We try to avoid that.
I know you try.
That hasn't happened recently, has it?
Has anybody been out to Costco to see that lighting?
I have not. It'll be more easy for us next week because we're daylight savings time.
Yeah.
So at 4 o'clock, it's gonna be pretty dark. At 5
Sure.
o'clock, it's gonna be pitch black, so I think it's swing by.
Good idea.
Yeah.
Ed, just so you know, I emailed Brandon Fitz, asking for a copy of an invoice or something from the manufacturer to show what they actually installed out there. All he sent me was what they proposed through the site plan application. That's not what I wanted, and I emailed them back saying that's not what we want. We want something that shows what was actually installed.
Right.
Because I can't climb up a ladder to go up there and see what it is, so.
Let's make sure they're doing it right.
I've been out there to see it,
Oh, you have?
on the Brixmore side, not the
Yeah.
Costco side.
Yeah, the bricks, yeah,
Yeah, I mean, I don't know what the spec is exactly, but I was there before daylight in the morning, and they seemed fine, directing straight down, good
Okay,
visibility.
If they're
with it.
okay, they're okay. If they're not, then we
And I
should.
do know that they did replace them all from an earlier version, including the ones that were part of the Costco.
It was done already.
Okay.
They replaced them. But you said you're gonna take a look next week.
Yeah, I'm gonna take a look next week, and also, like I said, I'm gonna hold Brandon's feet to the fire. I wanna see a copy of whatever invoice that they got from the manufacturer to see what they actually installed and compare it to what. Do we know what was specified? What's that? We know what was specified?
Yeah, it should be.
Yeah, it's specified in the lighting
In the
plan,
lighting
and we
plan.
actually have the cut sheet with the manufacturer name on it, so whatever they installed out there should be consistent with that.
Emily, is this your last meeting?
Yes, it is.
Well, on behalf of the board, I want to thank you for your outstanding service. We're definitely going to miss you. You know, it was great having your organization and getting everything to us on time and keeping us in line, and me especially, coming to sign stuff. So you will be missed, and thank you. And welcome to Carissa. We look forward to working with you, and we'll try and break you in very easily. All right?
Where did you come from, Carissa?
The town board office.
Oh,
Right across the hall.
I'm a coordinator.
Yeah.
yeah.
I don't know why anybody would want that job.
Okay, motion to adjourn?
Motion to adjourn.
All in favor?
Aye.
Aye. Okay, thank you.
You too.
Have a nice weekend, everybody. Good luck, Emily. Welcome, Carissa. Adios, Tim Gannon.
What's that?
Discussion there, public hearing.
No, it's only a public hearing.
The only approvals today were DSA Capital, Wall, and